Go ahead.
Thanks, Lisa. I'm Kathy Marquis, and I'm the Wyoming Interim State Archivist. And on behalf of the Council of State Archivists Education and Program Committee, I'd like to welcome everyone. And I'll be announcing speakers at the beginning just to ease the transitions between the speakers. But I'd also like to mention that we are normally joined by Meg Phillips, External Affairs Liaison with the National Archives, and Barbara Teague, Executive Director of CoSA. And I did see Barbara's name on the attendees. So I guess they lurk, but they're also there for us to ask questions or to join into the discussion. So our presenters today are Jeannette Wise, Director of Litigation, Office of General Counsel at the National Archives; Martha Murphy, Deputy Director, OGIS, Office of Government Information Services at the National Archives; and Rosemary Cundiff, Ombudsman at the Utah State Archives. So I'm going to give you a little bit of introduction to who they are and what their backgrounds are, and then we'll get started with Jeannette. So Jeannette Wise joined the National Archives as the Director of Litigation within the Office of General Counsel. In this role, Ms. Wise provides legal and policy advice to NARA officials and employees and liaises with the Department of Justice and other federal agencies as NARA's counsel in legal proceedings involving the Freedom of Information Act, the Federal Records Act, the Presidential Records Act, the Privacy Act, and other NARA-related laws and regulations. In addition, Ms. Wise supervises the Office of General Counsel's FOIA team, which has primary responsibility for handling NARA's FOIA requests for operational records. Ms. Wise also provides legal advice and guidance on administrative proceedings involving employment and personnel law matters. Prior to joining NARA, Ms. Wise served as an Assistant General Counsel in the litigation branch of the FBI's Office of the General Counsel for over 6 years. In that position, Ms. Wise served as FBI agency counsel for FOIA litigation matters and administrative employment law matters. Prior to joining the FBI, Ms. Wise worked in private practice as a litigation associate at the law firms of Winston & Strawn in Chicago, Illinois, and Wilkie, Farr & Gallagher in Washington, D.C. Ms. Wise received her JD from Harvard Law School and her BA from Wittenberg University. Our second speaker is Martha Murphy. Martha Murphy joined the Office of Government Information Services, OGIS, at the National Archives as the Deputy Director in July 2018. Ms. Murphy has played a critical role in OGIS's ongoing work to resolve FOIA disputes, assess and improve agency compliance with the statute, and educate the public about FOIA. Ms. Murphy has a broad range of experiences in FOIA, ranging from processing records for release, managing a successful FOIA program, and settling nationwide FOIA policy for agency records that are part of NARA's collection because of their permanent historical value. Prior to joining OGIS as the Deputy Director, Ms. Murphy was the FOIA Program Manager in Research Services at NARA. In this role, she led several high-profile efforts to provide public access to records, including the JFK assassination records collection. Ms. Murphy also oversaw a staff that handles regular requests for a wide variety of records in the National Archives holdings. Ms. Murphy has been a valued member of the National Archives family for many years. She first joined NARA after completing a 2-year archival training program, then worked as an archivist in the Center for Legislative Archives, Special Access, and FOIA staff, and with the JFK assassination records collection. In 2016, she was recognized for exceptional service by a FOIA professional by the U.S. Department of Justice. Ms. Murphy holds a bachelor's degree in history with a minor in political science, cum laude, from the Loyola College, Baltimore, and a master's degree in 20th century American history from Loyola University of Chicago. Our final speaker will be Rosemary Cundiff. Rosemary Cundiff is Utah's first government records ombudsman. She was appointed as ombudsman in 2012 when the legislature created the position. In that role, Rosemary is required to be familiar with the provisions of the Government Records Access Management Act, GRAMA, so that she can assist government employees as well as the general public with issues related to records requests and appeals. Rosemary has worked in various capacities at the Utah State Archives for 19 years. She has a master's degree in American history from the University of Delaware. And with that, I'll just give you a brief overview of what we will cover today. The three speakers that I mentioned, and we will follow that with Q&A, so get your questions ready. And then I think at the end, Lisa will have some announcements for us about upcoming events. So I'm going to turn it over to Jeannette, and we will have our first presentation. Thank you.
Thank you, Kathy. Like Kathy said, my name is Jeannette Wise, and I'm the Director of Litigation here at the Archives. And I'm just going to give you a very brief overview of kind of how FOIA works here at NARA and what some of our challenges are in terms of meeting our mission of providing, making access happen. Sorry, my slides don't want to advance. Kathy, oh, there we go. Okay. So this is just the legal citation to the statute. Obviously, the purpose of the federal law, Freedom of Information Act, and I know most states have a comparable law, many of which are based on the federal law, are very similar to it, which is essentially gives any person the right to request access to the federal records. And obviously, the purpose of FOIA is to facilitate transparency and accountability so that our citizens, and actually you don't have to be a citizen under the federal law to request access to federal records, but to give individuals an opportunity to understand what our government is up to and how we are operating our agencies and other organizations. The presumption under the FOIA typically, of course, is disclosure. So as you move forward through, when we receive a request, we can't just assume that we can hold everything. The presumption is that everything should be released unless, of course, some information falls within one of the 9 specific exemptions that are allowed for withholding information under the FOIA. The federal law only applies to executive branch records. So many requesters get very confused on that purpose. And although NARA does hold a collection of legislative and judicial branch archival type of records, those, and also I should mention also other donated materials, those materials are not subject to the FOIA. There are different means and mechanisms by which those materials can be accessed, but they are not subject to the FOIA and are not accessible under FOIA. And then there's just a definition of what an agency record is, and generally it's any type of paper or document. The important thing to note, of course, as we've moved into the electronic age is that audio, photos, emails, and things like that are, of course, records as well, which I'll speak to a bit later in terms of why that sometimes, particularly with respect to emails, can cause a challenge for us. As I mentioned, NARA's core mission is to make access happen. And so we do that through a number of ways, and FOIA is just one part that supports that core mission. I tried to pull through some statistics recently, that NARA holds over 5 million cubic feet, which is the equivalent of 12.5 billion pages of permanently valuable archival federal and presidential records. In addition, we have 795 terabytes of electrical archival records. And so obviously there's a lot of information, and we do our best to make that information available through our public research rooms, through our catalog, and one of the things that I know that we've been working on and is an emphasis of the agency is digitization efforts. And so essentially to make, as you can imagine, we have a lot of paper records, and to make those paper records available in a digital format so that they're more easily accessible to the public. So let's talk a little bit more specifically about FOIA and how it works here at NARA. So there's kind of 2 different categories of FOIA, or categories of records, rather, that you can access under FOIA here at NARA. You have the operational records, which are the records that NARA creates in the course of conducting its business and fulfilling its mission. So any record, emails that I'm sending, advice that I'm giving, all of that is considered operational. Archival records are records that were created and have been deemed largely from other agencies, but also our own records can become archival, but that have historical value and have been deemed permanent records with historical value and significance. So there's different ways in which the FOIA exemptions apply to the different types of records, which we'll talk about a little later. In my office here, Cassie referenced, we process operational records within our office. I have 3 archivists on our staff and a government information specialist who works on processing NARA's operational records. But let's give you an overview of kind of the different offices. NARA and FOIA at NARA is essentially what we call decentralized. So you can make your request to the specific office that handles and has expertise in a certain category of records. It's not a requirement, but it will be handled. A FOIA request, once it's received, will be handled by a specific office based on the nature of the records that are requested. So like I mentioned, if you're requesting operational records, those would be handled here in my office in College Park, Maryland by our FOIA staff. If you're requesting archival records, then it depends. And so there are several different places where it may go. So there's the reference section and division within NARA and its special access divisions. There's offices located here in College Park that process for a request for archival records of executive branch agencies that are in the Washington, D.C. area. But we also have regional archives located around the country that handle their own FOIA requests directly. In general, though, they don't get as many requests. The bulk of those and the numbers that we receive in terms of requests come through and are handled here, mostly in the D.C. area. In addition, we have the National Declassification Center, which is also located here in College Park, and their specialty is handling classified archival records. And so there's a different process that's required, and by classified we mean records that are deemed sensitive with respect to national security, foreign policy type of issues. And as I mentioned earlier, there are archival records in different field locations. So there's different regional field archives across the country, including one that's in St. Louis that is co-located with our St. Louis National Personnel Records Center, which I'll talk about in a moment, that handles different military and civilian personnel files. Also, another portion of NARA's records is obviously we run and operate presidential libraries across the country, and presidential records, beginning with President Reagan forward, are subject to FOIA pursuant to the Presidential Records Act. And through that act, records are subject to FOIA 5 years at the end of the president's administration. So we do request once in a while for President Obama records, but they are not yet subject to FOIA. And then also just as a general overview to kind of round this out, we also process records on behalf of other agencies under FOIA. So we have these, like I said, the National Personnel Records Center, which is outside in St. Louis, located out in St. Louis, Missouri, which handles military personnel files. OMPFs are official military personnel files, and other type of health and medical related records of veterans. And we do that on behalf of the various military branches and services. And so our provisions and our work for them is guided by their principles and those military branches and principles, but we do it on their behalf. Similarly, we also handle civilian personnel records. So for any former or separated federal civilian employee, many of those personnel files are located in our Valmeyer, Illinois facility. And so if someone needs, for whatever reason, to access or wants information about a particular civilian employee service, those requests are made through the Civilian Personnel Record Center in Valmeyer, who then works with the respective agency to provide access. So to talk a little bit about our processing challenges, like I mentioned, well, I guess let me just back up and say there's kind of four main steps to FOIA, right? So you receive a response. You then have to do a search, and there's legal requirements for what your search is supposed to include. And then you have to respond, do the search, you receive the request, you do the search, and then you, process the records, and then you provide a response. And FOIA requires that there be a line-by-line review of information prior to it being released. It also requires you to make sure that you segregate information within the request, meaning if there's a name, for instance, within a paragraph, you obviously shouldn't redact the entire paragraph. You only want to redact the name. So because of that, it can be quite time-intensive, and the statutory deadline under the federal statute is that we are supposed to respond to the requester, meaning fully respond in terms of providing records within 20 working days. As you can imagine, for many agencies, NARA included, 20 working days is a very, very high hurdle to meet. And we do our best, obviously. And I will say as an agency overall, we definitely work towards, releasing as much as we can, obviously. Like I said, our mission is to make access happen. So we only redact where necessary, but there are still times in which documents have to be reviewed and redacted where necessary. As you can imagine, this then leads to backlogs. And so I know in our office here, we have a backlog of about 160 actual FOIAs, and we have backlogs across the agency, unfortunately. That's a reality, I think, amongst all federal agencies, or most federal agencies, I should say. And then what leads to that, and kind of in conjunction with, the short time period, which leads to backlogs, is essentially the number of requests that are received and the volume of potentially responsive records. And as I mentioned earlier, one of the things that has astronomically increased the amount of potentially responsive records is the creation of email. And that's much more so on the operational side, obviously, but sometimes it's also becoming more of an issue on the archival side as well as records get older, and as we've been using email for some time now. And so you're required under FOIA to do a reasonable search for records that are likely to produce all relevant documents. And so in doing that, lots of times with the advent of all of our new technology, it requires or produces a larger volume of potentially responsive records that then have to be reviewed, which of course means you need people and technology to do that review, which of course requires money. And we are often financially challenged in that situation. So we're required to kind of work with the resources that we have available. And before I get into this, and I know I have a couple of minutes to go through this, but before I just mention this, I did want to give you guys an overview of generally how many requests that we received here at NARA last year. So for fiscal year 19, which would have ended at September 30th of this past year, or this year, we received a total of 67,432 FOIA requests, but a large portion of those requests were handled by our military, our NPRC facility, the National Personnel Records Center in St. Louis, on behalf of other agencies. So that portion was 61,272. Of actual requests that we handled for NARA records, our research services divisions received 4,384 requests. We in our office here in the Office of General Counsel handled 531 requests. The presidential libraries received 666 requests, and our classified records division received 280. So I just want to quickly go through what some of the common reasons are in which access will be restricted in our records. Largely, one of the things we will see is personal privacy, which is Exemption 6 of the FOIA, and that requires a balancing test to determine whether or not the public interest in the information would outweigh the individual's personal privacy. But because a large portion of records are archival, obviously, as time passes, obviously the public interest and the personal privacy interest, that balance will tip, such that I think our policy is that obviously if a person is deceased, they no longer have personal privacy, so that gets released. And then there's guidance with respect to, I think it's like 75 years that information will be released. Another big challenge that we have are Exemption B3 statutes. And essentially a B3 statute is a statute that specifically allows particular types of information other than the FOIA statute itself to be exempted from release, such that it doesn't have to be released under the FOIA. Such an example is tax records. We have a lot of ongoing litigation related to grand jury material and requests that people have wanted to see or requests people have made for information they want to see under grand jury. And unfortunately, NARA doesn't have the authority to simply just release grand jury material, so it leads to more litigation. Similarly, there's court-sealed records. So if records have been sealed by a court, then technically there's a court order that's still valid that's controlling that record. And so that requires some extra work on our part as well in terms of being able to provide access. We also see, and we have a large collection of FBI records, and we will often see source information and FBI sources. FBI continues to hold source information for a very long period of time. And so we do not provide source identifying information. So that's withheld under B7D. We also obviously would continue to hold classified information to the extent it remains classified. NARA doesn't have the authority or has very limited authority to declassify information, and so we have to work in conjunction with different agencies or whoever the original classification agency was in order to determine if the information can be released. Two other very quick things. Before records become archival, lots of agencies will withhold information under what is called Exemption B5, which deals with deliberative process or deliberations between an agency or within an agency. It also would cover attorney-client privilege and attorney work product. That only applies to operational records. Once a record becomes archival, NARA no longer applies Exemption B5. And then lastly, we will sometimes have information, obviously in contracts, this comes up a lot in terms of trade secrets and commercial financial information. So I'm sorry, I think I ran a bit long, but I'm now going to turn this over to Martha Murphy at the Office of Government Information Services to talk about OGIS. Oh, and just FYI, there's my contact information, should you have any questions.
Thanks, Jeannette. Can everybody hear me?
Yes, we can hear you.
Great. I'm trying to get the slide to move. I think it takes a second to end here. I'm just going to go ahead until I can get the slide just to forward. This was working earlier. First off, just thank you so much for the opportunity to talk today. I think Jeannette has provided a nice overview of federal FOIA statute and how it's applied at NARA. I'm going to be explaining where OGIS fits into the federal FOIA process, what our role is, and how we carry it out. And I'm still not able to advance the slides, guys. So let me try again. There we go. Thank you. So FOIA revolutionized government openness, obviously, but it also created a conflict. There's an intrinsic tension between what the requesters want and what the agencies can provide. And so how has that tension played out historically? Well, prior to the creation of OGIS, through the Open Government Act of 2007, if a requester was unhappy with the response they received from an agency, they could submit an administrative appeal to the agency where another component within that agency reviews the response to make sure it's appropriate. And then if they were still unhappy, their only recourse was to sue the agency. As a result, FOIA litigation has proliferated over the years. Requesters have sued on how their FOIA was administered, for instance, how quickly they got a response, the sufficiency of the search, those types of things. And they've also sued over the decision made on the release of records, whether the application of the 9 FOIA exemptions was appropriate. I had a colleague once in training who said he thinks every word in the Freedom of Information Act has been litigated. I think he's about right on that. So Congress had long recognized that there was a need for some alternative method of dispute resolution in regard to the FOIA. By passing the Open Government Act in 2007, Congress created OGIS to provide a non-exclusive alternative to litigation. At the time of passage and since, Congress has referred to OGIS as the FOIA Ombudsman. So what does it mean to be the FOIA Ombudsman for the federal government? Well, Congress gave us 2 very clear missions in the statute. First, we're charged with providing mediation services or dispute resolution services to help resolve disputes between individual requesters and federal agencies. And second, we have the responsibility for reviewing agencies' policies and procedures and looking at it from a compliance perspective. When we formally opened our doors in September of 2009, we had a staff of 2, OGIS's first director and an administrative assistant. We currently have 9 full-time employees and 1 temporary part-time student until the end of January. I'm sure you all feel our pain on that one. We have split our offices into 2 teams, a mediation team, which handles the individual requests for dispute resolution regarding FOIAs with federal agencies, any federal agency in the government. And secondly, we have a compliance team. That compliance team reviews government regulations. It conducts assessments of agency FOIA programs, and also conducts assessments of FOIA processes that cut across federal programs. I'll talk a little bit more about that in a second. In our mediation program, we play the role of a neutral party. We advocate for the FOIA, not for the requester or the agency. Often our role is to clarify misunderstandings between the parties and to provide direction for requesters as to what their best next steps are. In a dispute, we take the side of the FOIA and the FOIA process. So we're not the FOIA police. A lot of folks come to us, they'll even say, I want you to investigate this FOIA process. They're not acting in good faith. And we have to explain, okay, that's beyond our scope. You should go to the Inspector General if you have an issue like that. But we are happy to go in and ask questions and look at the process. We're averaging about 4,500 inquiries a year, about half of which are phone calls that are handled very quickly. The other half are correspondence. These inquiries are handled by 4 staff members. And since we began offering dispute resolution services in 2009, we've come into contact with thousands of FOIA requesters and FOIA professionals at most of the more than 100 agencies and departments that are subject to the FOIA. Let me explain a little bit more about our dispute resolution program. The first thing to know about our program is that we do not dictate solutions or tell agencies that they have to turn over records. Our mediation services are completely voluntary, and we have had both agencies and requesters at times decline to participate. So if either party declines to participate, there's no role for OGIS. Most often, we act as a facilitator to help agencies and requesters better understand the issues and each other's parties' positions. The statute specifically says our mediation services are non-exclusive, alternatives to litigation. We try to prevent litigation through our dispute resolution, but there's nothing in the statute that prevents a requester from filing a suit after going through our process. But a lot of times, the explanations we provide let the requester better understand the agency's response. So we look to the agency to help us to provide a more detailed explanation. And we do a lot of shuttle diplomacy, mostly not face-to-face, mostly via emails and other. Generally, once a case is in litigation, we have to step back. We don't have a role at that point. So while the mediation team looks into the FOIA in the micro level through individual disputes, the compliance team works to improve FOIA in the macro, conducting assessments of agency FOIA programs and conducting research and writing assessments about issues that cross agencies. Our compliance program was not formally created until a few years ago, but we now have a fairly robust agency assessment methodology. Our assessment reports, which are all on our website, include a thorough review of the agency's management and communication practices and their use of technology, and we provide recommendations for improvement. The process is voluntary. Agencies come to us to request that we conduct an agency assessment. So we aren't like an inspector general who's conducting sort of a legal audit. They're coming to us. We're using a lot of those auditing techniques, but it's a voluntary process. We follow up with the agency 120 days after the report is issued to see what steps they have taken to address our recommendations. So far, we've reviewed FOIA programs at the National Archives. The archives were our guinea pig, including my previous organization. So I was involved in one of the first of our assessments from the agency perspective. Various DHS components, including the DHS FOIA Privacy Office, U.S. Coast Guard, Customs and Border Protection, FEMA, Immigration and Customs Enforcement, and TSA, U.S. Secret Service, USCIS. We've also conducted assessments of the Consumer Financial Protection Bureau, U.S. Postal Service, and the U.S. Department of Education. At this point, the FOIA programs we have reviewed have addressed 98% of our recommendations, which is encouraging. So these two teams really do complement each other. Our dispute resolution program gives us a front row seat for problems between requesters and agencies, and it allows us to identify areas for improvement government-wide that may be ripe for an issue assessment to be conducted by the compliance team. As I mentioned above, our compliance team also conducts assessments of possible government-wide compliance issues. We've issued assessments regarding the use of something called a still interested letter. These were letters that were sent by agencies for FOIAs that had been sitting in the queue for a very long time, and sometimes if people didn't get back to them, we're administratively closing them. So we did an assessment on that. We've also discussed agency compliance with notification of dispute resolution services, which was a requirement of the law, and we determined whether or not agencies are complying with that. And we conducted an assessment on how agencies have leveraged technology to improve FOIA searches in the electronic age. And that grew out of a question from something called the Chief FOIA Officers Council report to the Department of Justice. I'm sorry, the Chief FOIA Officers report to the Department of Justice. So the question asked, this question in particular, asked Chief FOIA Officers to detail specific methods and technologies that agencies are using to search their electronic records, including email. So as you can see from the image I have up on this slide here, the members of both teams also take on other roles and wear other hats. We have a robust outreach program that includes participating in forums like this one, holding our own training events, maintaining our web presence by regularly updating our blog, maintaining our website, and of course, we have a presence on Twitter. Our outreach efforts ensure that we're constantly engaging with our stakeholders, both agency and requester, and we try to learn more about their views on the FOIA process. Our two team leads conduct a very popular one-day dispute resolution skills training class. We often are asked by agencies to come and conduct the training for their FOIA professionals as part of a yearly training program. And the purpose of this course is not to make attendees trained mediators, but to give FOIA professionals the practical skills they can use to improve their communication with requesters. We're often urging FOIA professionals to get on the phone and ask the questions that can help the process. In addition to our work on dispute resolution and compliance, we have a number of other initiatives. In 2014, we launched the FOIA Advisory Committee, which brings together FOIA experts from inside and outside of government to collaboratively develop recommendations to improve the administration of the FOIA. Each FOIA Advisory Committee has a 2-year term, and we're in the third iteration of that. During its first term, the committee yielded one recommendation and numerous suggested best practices. In the second term, there were 7 recommendations and even more best practices. We're about 3/4 of the way through the committee's third term, and we're very excited by the recommendations that are currently under consideration, which should be coming out, I believe, in June. We also co-chair the Department of Justice's, with the Department of Justice Office of Information Policy, something called the Chief FOIA Officers Council. Every agency needs to have a Chief FOIA Officer. We host annual meetings of the council where we convey information to the Chief FOIA Officers. And last year, the CFO Council established a subcommittee to look into issues of technology and FOIA. And that committee has been working very hard for the last year to assess the current technology landscape and is drafting a sort of white paper on their findings with recommendations. OGIS also hosts an annual open meeting to allow the public to learn about our reviews and reports and submit comments. And we publish an annual report, which is submitted to Congress and, of course, posted on our website. As the FOIA Ombudsman, we believe engagement is a critical component of our work. In light of that role, we also organize and host the National Archives' annual Sunshine Week event, which occurs every March. All of these meetings are live streamed, and they're available for review on NARA's YouTube channel. So ultimately, the goal of OGIS is to work to improve the FOIA process for both requesters and agencies, whether individually or through an assessment identifying areas for improvement. We're a small but mighty staff, but I think I'll stop there and pass it along to Rosemary.
Hello, this is Rosemary, and I appreciate this opportunity to talk today about transparency in Utah and the initiatives that Utah has taken to promote government transparency. So Utah's equivalent to FOIA is the Government Records Access and Management Act. The Government Access and Management Act is called GRAMA, and so in Utah, people refer to records requests as GRAMA requests. So GRAMA was passed in 1991 and went into effect in 1992, and it is set up as establishes a process by which the public can make records requests, and also establishes the process by which government is to respond to records requests. So the legislative intent section of GRAMA describes the competing interests of personal privacy and public interests, and states that it is seeking to balance these two constitutional rights, these two interests. It also describes that there is a public interest in restricting access to some records and is balancing the public interest in access versus the public interest in restricting access. The legislative intent also goes on to say that the intent is to promote easy and reasonable access to all public records, and to, on balance, when the interests in restriction of access are equal, to favor public access. GRAMA goes into specifics about what records are public and what records are private and protected. So some examples of records that are public are minutes and recordings and transcripts of open meetings, judicial records, unless the court has ordered restriction, and records that are maintained by recorders and clerks and surveyors that describe property rights and tax status. There is a lot more than this on the list of public records, but this is an example of some of them. And then GRAMA also provides lists of private records. And one example of private records is employment records that include home address and home phone number, social security number, insurance coverage, marital status, payroll deductions for all government employees. So that's an example of private records. Then there are 75 identified protected records in GRAMA, and a few examples of those are records that are subject to attorney-client privilege, or records that are prepared in anticipation of litigation. Also, drafts are protected records. And protected records are restricted in the public interest, whereas private records are restricted for individuals' personal privacy. So in Utah government, each governmental entity is responsible to classify their own records, and they can pre-designate classifications at any time, but they don't actually review the records to make a final classification determination until the record is requested. And then, of course, as situations change, records can be reclassified. Every governmental entity is required to appoint a records officer. And the records officer is responsible for managing records and also making classification decisions for responding to GRAMA requests. In Utah, in order to ensure that the records officers are competent, they are required to certify annually by completing online training. That is to cover the statutes of GRAMA. And the State Archives provides this certification process and hosts this test. So GRAMA says that every person has the right to inspect a public record free of charge and the right to take a copy. So this right is extended to everyone. You don't have to be a resident of Utah or a citizen, and it doesn't matter the reason for your request. Private records, on the other hand, are disclosed only to certain individuals, the person that the record is about, or a guardian or parent, or someone with an authorized, with notarized release or power of attorney. So GRAMA outlines a specific process for making requests. A person who is making a request has to provide their request in writing. It has to include their name and contact information, and then a specific description of the records that they're requesting. That's so that the records officer can understand what records are being asked for. After receiving a GRAMA request, a records officer has 10 days to respond, 10 business days, and the records officer can respond by approving the request and providing records, or notifying the requester that they don't maintain those records. They can respond by claiming extraordinary circumstances, and that essentially means that more time is needed to process the request. The extraordinary circumstances are specifically outlined in GRAMA and how much time for each extraordinary circumstance is allowed. Then finally, if the records are classified as private or protected or restricted by some other statute, the records officer will deny the request and provide the requester with a legal citation that is the basis for the denial and inform the requester that they have the right to appeal that denial. There is a quasi-judicial process by which the public can appeal denials to requests. So the first level of appeal always goes to the governmental entity's chief administrative officer. So, for example, for a municipality, that would be the mayor or the head of a state agency. And that gives the chief administrative officer the opportunity to review the records officer's work and to either support the denial of access or overturn it and provide access or some combination of that. If the Chief Administrative Officer upholds the denial. They inform the requester of the right to appeal to the State Records Committee. The State Records Committee is a 7-member body, volunteers. They hold hearings once a month and listen to the arguments of each side of each records dispute. So after listening to each side's argument, they deliberate openly and make a decision about which side they think is right, whether records should be provided or whether the governmental entity has made an appropriate classification decision. So after the Records Committee makes this determination, they issue a decision and order, and the parties must comply with the decision and order. If they don't like it, then they have the opportunity to appeal that decision in district court. So as time has passed, of course, there's more and more expectation of transparency and requests for records and more hearings. And so 7 years ago, the state legislature in Utah created the position of Government Records Ombudsman to help augment this process. So the Ombudsman, according to the law, must understand GRAMA so that she can act as a resource for governmental entities as they respond to GRAMA requests. Someone they can go to discuss how they should classify, bounce off ideas. Also, the Ombudsman is a resource for the public who want to access records. They can call the Ombudsman and ask about the process or where to place requests, anything like that. The Ombudsman also mediates disputes. So this would work alongside the Records Committee. As the appeals go up to the Records Committee, the Ombudsman might step in and invite the parties to sit down together and discuss things, potentially work out a compromise. The mediation process provides a lot of alternatives besides just a committee deciding which side was right and which side was wrong. There can be a compromise. Some additional legislative initiatives in Utah that promote transparency are the Open Records Portal and the Public Notice website. The Open Records Portal is a central website where the public can go to make records requests to any governmental entity in Utah. It also provides links to records online. This portal is kind of a project in the making. There's a lot still that we can do with it, but so far the public records requests going through the portal are increasing rapidly each year. And then the other is the Public Notice website. The Public Notice website is also hosted by Utah State Archives, and it is a central place where the agendas and notices of all public meetings must be posted, and where governmental entities can also upload the minutes and recordings of their meetings to make them accessible to the public. So that's a broad overview of Utah and how GRAMA works and the processes that support it. And as mentioned, I am Utah's first and only Government Records Ombudsman, and I have been very busy for the last 7 years. And I believe that government transparency is very important for the support of government, for prosperity and civility in our communities. And with that, I think I will turn the time back to Kathy.
Thanks to all of you for all of these presentations. I think we have a much better idea now of how your offices work and some of the challenges that you face. And I can see that several people have already indicated that they have questions. And so I think we will move on to that. The first question that we have is, as a military archivist, I deal with a lot more recent military records with classified or restricted marks donated in veterans papers from the public. What are my recourses for review of the restrictions as a non-federal government agency? I've checked with the Army, Marine Corps, and Air Force offices at the bases and state for advice, but they mainly follow their internal policies that don't apply to a state-level organization or university. So what would be your guidance? Jeannette or Martha, is that something that you could handle?
Hi, this is Jeannette. You know, I don't have a great answer to that other than to say I haven't dealt with a lot of kind of military records myself, but and Martha may have, may have some insight into kind of best practices for that. But I would think, I'm assuming this is information that is in your possession. I guess I have a couple of reactions. First is, if it's truly classified information, I would think that those agencies would have some concerns and would want to talk to you before that information is released. And obviously there would be controls and whatnot in terms of the type of information. So I guess I'd need to know a little bit more about the actual particular records. And so if you want to contact me offline, I'm happy to kind of talk more through that. And maybe we can actually put you in contact with some of our folks here who may have kind of other resources within the military who could help you.
Thank you very much. I think we'll move on to the next question, and this is for Rosemary. In Utah, records that have attorney-client privilege can never be accessed according to GRAMA. Is that true? And do those records go to the archives, and are they ever opened?
Okay. As far as attorney-client privilege, so GRAMA has a provision that records are public after 75 years, or it actually says that when the reason for the restriction no longer exists, that the records should become public, and it's presumed that records should be public after 75 years. And so it doesn't specifically address the attorney-client privilege, but in my conversation with the Attorney General's office here, the expectation for attorney-client privilege is to be restricted forever. And so once the records would come to the archives staff has a responsibility to make classification decisions because the records are then in archives custody. And I don't know the answer to whether or not we have restricted access to records in our custody based on attorney-client privilege. I don't know if that adequately answers the question, but as far as I know, attorney-client privilege is forever.
Okay. This is Kathy. I'll just ask, could they potentially be opened by a court?
I assume so.
Okay, so that would be the ultimate recourse.
Yes.
Okay. All right. So I think this is for Rosemary as well. If your state was developing an open records request procedure, what advice would you have? Have there been unintended consequences in your laws?
I think the process is pretty good. It balances the public's right to access records and gives them a recourse, a venue for appeal, and a venue for opening conversations with governments. I think one of the frustrations for government is that there are people they call vexatious requesters who make a lot of requests and put somewhat of a burden on government, and being able to navigate that and deal with that is a challenge for some. And trying to think. I think the Open Records Portal is a good idea. It provides an avenue for people to make requests and to see who the records officers are and to just be able to navigate the process better.
And do you monitor that portal?
I don't personally, but we have someone on our staff who does.
Okay, thank you. The next question is, are there other states that have broader open government responsibilities for the state within their state archives and records management program? Rosemary, I don't know if you're aware of any of those.
Are there other states? I didn't realize that question was for me. Are there other states?
Are there other states that have the broader open government responsibilities for the state within their state archives and records management program?
I don't really know what other states are doing, but certainly here in Utah we have very broad responsibilities for providing access and for working with the governments throughout the state to provide access. I know that Oregon was looking at our Open Records Portal and possibly trying to do that for their state. Maybe someone else knows more about what other states are doing. I'm not sure.
If anybody wants to type in any answers to that into the chat, I can read them aloud too. I know here in Wyoming, our ombudsperson is situated in the governor's office. So that's, it's not that the archives has nothing to do with the process, but that's where that person sits.
It's interesting to me that this position sits in the archive.
Mm-hmm.
Because I'm not an attorney, but a lot of the people I deal with are attorneys for government and attorneys for requesters.
And we just had a response that from North Carolina, the Open Government Unit is under the North Carolina Department of Justice. So like archives, we sit in a lot of different places.
Yes.
And answer a lot of different bosses. I'm going to ask Lisa, do we have time for one more question or should we wrap it up?
I think we should go ahead and do we have a question for Martha? Oh, I see we have another one on the screen too. Yeah, I think we can do one more real quick.
Okay, sorry. So in Utah, what are the prerequisites or job qualifications for the Open Records Ombudsman?
That's a really good question because the legislature passed the law in 2012 and it says that the state archivist shall appoint a government records ombudsman, and then it lists the responsibilities of the ombudsman, but it doesn't state any requirements other than the ombudsman must be familiar with the statute. And so when the law was passed, I was working at the archives already and doing training on GRAMA and records management. And so I got the appointment, and so far I'm still doing this job, and no one has ever applied for it. And so I guess we'll see.
And I should just add, we'd had one more response that the public access counselor in Illinois is under the Illinois Attorney General. So again, yet another spot to sit in. Probably at this point we should wrap up our presentations, and I want to thank all of our presenters on behalf of the CoSA Education and Programming Committee. We all have so much to contribute and so much expertise, and we are very grateful when people are willing to take the time and share that information with us. And then I'm going to turn it back over to Lisa for some announcements.
Thank you, Kathy.
Lisa, we can't hear you.
Oh, no. Okay.
Okay, now we can.
There we go. Sometimes there's a little bit of a lag there. Sorry about that. Kathy, just go ahead and advance the next slide.
Oh, we lost you again.
Okay. Can you hear me now?
Yes, you can.
There we go. Yeah, again, as the old admin says, sorry about that. Can you go ahead and advance the slide for me, Kathy? It looks like Becky hasn't been able to.
You're really fading in and out.
Okay, sorry about that. Okay, there we go. First of all, we want to remind everyone to stay connected. Can you still hear me?
No.
No. Okay.
Now we can.
Now we can. Okay. We want to remind everyone to stay connected. We'll always place the live to do that, and of course, staying connected with NARA as well. We really do appreciate all of your feedback, so do take time to do the evaluation for us. And just one final last little thing. From all of us at CoSA and NARA, happy holidays, and just remember, Christmas calories don't count. So thank you, everyone, presenters. Happy, thank you for being our moderators. Attendees, I hope you enjoyed today's webinar, and we hope you have safe and happy holidays, and we'll see you guys in January. Thank you all for attending today.